So what is evidence? What is Evidence Act? It is the law of proof in India. So for any issues or any cases, we have to prove it, right? So we have to prove the facts. And it tells you what facts can be proved, how can they be proved, and what the court can rely upon. So what are the things we have to prove, how it is to be proved, and what things court will rely is about Evidence Act. Okay, Evidence Act talks about these things. So evidence definition is given in section 3. 1 minute. Evidence definition. Yeah. So all definitions are given in that section 3 only. Code, fact, relevant fact, facts in issue, document, evidence. So evidence is also defined in section 3. There are two types of main evidence, oral evidence and documentary evidence. So oral evidence is where witness will come into the court and give his oral evidence. Okay, documentary evidence is where we produce certain documents in the court. Okay, so why we have to prove something to establish the truth, to establish the truth. 1 minute. To aid judicial determination, to prevent falsehood and fabrication. Okay, basically evidence is used to determine that, to establish the truth and for helping judicial determination in giving the judgment. There are certain fundamental rules for evidence. Okay, evidence should be confined to the matter, facts in issue. So you need not give any evidence which are not facts in issue or which is not concerned with the matter of the case. Okay. Hearsay evidence should not be admitted. So there was somebody was discussing in the group what is hearsay and exception for hearsay. Okay, res geste. So we'll talk about that over the class. Okay. So this is res geste is a very important term where you may get question. Hearsay evidence also you will get the question. Hearsay evidence should not be admitted. This is the fundamental rule. Best evidence rule or best evidence must be given in all cases. So every time you have to give the best evidence only. Whatever is the best alternative evidence, you have to give that. Okay. So these are the basic things. Hearsay, we'll talk about that one. What is hearsay evidence? Okay. Then there is another thing. See, I'm talking only about concepts. I will not take out the bare acts and speak. Okay. So we will talk more about the concept. Then again, we will go through some important topics again. So another thing is presumptions under Indian Evidence Act. This is another important concept. Presumptions under, I have given you chapters, right? Okay. In those chapters, we have discussed what are the important things. Easy to remember. There are 3 parts in Evidence Act. Okay. How many? 3 parts. Okay. What those parts will do, I'll tell you. But just I'll explain this and we'll go to that other important things. So presumptions, there are 3 presumptions which under Indian Evidence Act. So may presume. This is discretionary presumption. So it means the court may presume a fact. It is optional and it is not mandatory. So the court can either presume it true or call for further proof. Court, if you give some evidence and if it is presumption, court can assume it. I mean, it can take it as the truth or they may ask for more proof. Okay. But basically, the opposite party can disprove it. Okay, we'll talk about proving, disproving, all those things. So here under section 14, 114, the court may presume that a person in possession of a stolen goods after theft is either the thief or has received the stolen property. See here, you may presume. So if the thief, if there is a, accusation that there is a thief and he is found with some stolen property. So they presume that he may have stolen that, or he received that stolen property. He might have purchased it, or somebody has kept with him. So that is the presumption. Okay, so the opposite party, the accused, should disprove it. Shall presume. It is a mandatory presumption. So the court shall presume a fact. It must accept it as true unless rebutted. The burden shift to the opposite party to disprove it. Okay, so it can be disproved by evidence. So opposition party should bring some evidence to disprove that mandatory presumptions. Okay, so basically we use this in negotiable instrument acts, where a check was issued. When the check is issued, it is assumed that it is given for consideration, and if it is, there is no dispute about the signature on the check, it is presumed that it is for legal consideration only. Okay, these are the presumptions under Negotiable Instrument Act. And again, same thing, if the court shall presume abetment of suicide by husband or relatives when a woman commits suicide within 7 years of marriage and was subject to cruelty. This is another major mandatory presumption. Okay, so here the opposite party has to prove. Then conclusive proof, irrebuttable. So there is you cannot challenge such proof, conclusive proof. Okay, once a fact is declared by law to be conclusive proof, the court must accept it as final. No evidence is allowed to the contrary. This is legal and final and absolute. Okay, a child below 7 years cannot be example. These are the example, valid marriage, all those things. Section 82 of IPC, Section 112 of Evidence Acts, there are certain cases. So these are the examples of presumptions. Okay, presumptions are very important when you are dealing with a case, which you have to prove, which you need not prove, which you have to, it is accepted by the court. Okay, then there are different types of evidences. So we'll come again. So there are oral evidence, then documentary evidence is there. So oral evidence is, the sections I will tell you, but anyhow, we need not have that. 59 to 60 and 61 to 90 is documentary evidence. Then direct evidence, which we can see, we can feel, we saw that. Circumstantial evidences, which is indirect evidence. Documentary evidence is, document is given. Oral evidence, as I told, it is once the witness come and speak. Direct evidence is, you are the direct evidence, you saw that incident happening. Circumstantial evidence is indirect evidence. Primary evidence, again, this is primary evidence is in the document only. Where original document is submitted, it is primary evidence. This is another important thing. When original document or original thing is given, it is primary evidence. Original things. Okay. Secondary evidence is when copies are given, photocopy or some other substituted evidence is given, then it is secondary evidence. So primary evidence is the proper evidence. Secondary evidence will not be accepted always. Some exceptions are there for secondary evidence, but primary evidence is the main evidence. Okay. So, and where Evidence Act is followed is, Act is followed in civil courts and criminal courts also. Okay. So, I think that slide is there. Okay. So, evidence in criminal cases. See, this is very important when you are practicing criminal law. In any criminal law, if you want a person to be proven guilty, it should be proved beyond reasonable doubt. Not a small 1% of doubt is also there. He will be acquitted. So in criminal cases, the burden of proof is always on the prosecution. So the accused need not speak. He can keep silent. See, when you see in the movies, accused also is cross-examined. But in real life, very, very rare instances, accused will be prepared for cross-examination. Okay, only the prosecution evidences are cross-examined. Accused can keep quiet. He may not bring any evidence. It is his right, fundamental right. We spoke about fundamental rights, Article 21, right? So it is his fundamental right. He can keep quiet. He cannot speak against himself. He cannot give evidence against himself. Okay. So he need not appear for cross-examination. So here, burden of proof is always on the prosecution to prove that all the facts they have to prove every fact. Okay. Presumption of innocence. This is another important aspect. The fundamental principle also, until and unless the accused is proven guilty, he will be presumed as innocent. Okay. Then there is another thing called confession and admission rules. I'm not going section wise. I'm talking more about the concept. I'm going as a flow. Okay. See, admission is used in civil proceedings. Okay. Admission is used in civil proceedings. Confession is used in criminal proceedings. Okay. Admitting the fact, confessing a fact. Okay. Admission is in civil. Confession is in criminal. Okay. Example, somebody confessed that he has killed A, confessed that he has killed B. That is confession. Okay. So confession is accepting that by the accused. Admissions are accepting by the plaintiff or the defendant. Here both parties are there. Here in civil cases, both parties can bring, both parties will cross-examine each other evidences and witnesses. But in criminal, only prosecution witnesses will be cross-examined mostly until unless accused is prepared for cross-examination. Okay. Then relevance, motive, preparation and conduct. See, we have studied in the this thing, if they have to prove everything. Actus reus, mens rea, all those things. Relevance of motive, preparation and conduct, all those things. All those things they have to prove. Hostile witness handling. So hostile witness, some witnesses of the prosecution will turn hostile. Okay, then see, there are two types of examination. Okay, chief examination and cross examination. Chief examination is the examination done by the person who brings the witness. Okay, if you bring the witness and you are doing the examination, it is chief examination. You bring the witness, opposite advocate is doing examination, it is cross-examination. So, if you bring a witness and he become a hostile, then you have rights for cross-examination. Okay, you can cross-examination him if he becomes a hostile. Or else you do only chief examination, you ask the questions, you ask him to explain what happened. Then he will be cross-examined by the opposite advocate. Okay, cross-examination is done to prove that his examination or his witness is not valid. They will try to break the witness. They want to disprove whatever he is saying through cross-examination. They want to somehow contradict his statements through different ways of questioning. So that is the cross-examination, very important cross-examination for any criminal cases and even for civil cases also. Okay. Evidence in civil cases. So here, burden of proof lies on the party asserting a fact. See, facts can be asserted by both. Plaintiff can assert certain facts and the defendant or respondent also can assert certain facts. So the burden of proof lies on the person who is bringing that particular fact. And documentary evidences dominate here more than the oral evidence. Admissions in pleadings. If you admit in the pleading that, see, when you are giving a plaint, when you are filing a civil case, you file a plaint. Okay. The respondent or the defendant will give a written statement in response to the plaint. Okay. So you have to contradict or don't accept every fact in the plaint raised by the plaintiff. Even if you miss or if you don't accept, if you accept that in your written statement, I accept this particular fact, or you don't mention specifically, you don't deny specifically that you are denying that fact, then they may say that you are admitting that. So admitting in pleadings, that is pleading, what we call. So it is a primary and strong evidence. So if you give some fact, I will give an example. So here there is a consumer court case. I am only fighting that case. So the consumer court, I filed I'm from a opposite party. Defendant is called opposite party in the consumer case. Okay. So I'm representing a opposite party. So the consumer is a transport company. He purchased 5 trucks and there is some problem in the truck. So he filed a complaint that 5 trucks are not good. I want money. Something like that. It is a different case, but just giving an example. So I'm representing the opposite party. Please don't scribble on the screens. So I filed a maintainability. Maintainability is that it is jurisdiction related question. So I filed a counter saying that consumer forum is not having jurisdiction to try this case. Okay, why? Because he mentioned that he purchased 5 trucks. Okay, he mentioned in his complaint that he purchased 5 trucks and he is doing transport business. So he is admitting the fact that he is having 5 trucks and he is doing transport business and having other trucks also. He mentioned there in that complaint itself. And he is doing business since last 20 years. So consumer complaints is only for consumers, not for business people. So consumer means he should not be a business person and those things cannot be taken for business purposes. So I told consumer court cannot try this case because he has admitted in his complaint that he is running a business having multiple trucks. So that evidence is enough for me to show that he is not a consumer. So just because of that particular statement he is in complaint, I got that case dismissed. Okay. I got that case dismissed just for that statement itself. So otherwise it would have been difficult for me to, in the trial stage, that I will bring evidences that he is having more trucks, all those things. But in the complaint itself, he admitted that he is running a business of trucks, having multiple trucks, and he purchased 5 trucks. So nobody will purchase 5 trucks for self-use, right? Consumer use. Like I buy a car for my personal use. Okay, I cannot buy 5 trucks for personal use. Okay, so that particular admission in his plaint, in his pleading, is the strongest evidence. Okay. Then affidavit evidence common for interlocutor matters. Presumptions under, we discussed about the presumptions also earlier. What are the presumptions the court will take? Okay. So these are the evidences how we treat in civil cases. Okay, then it is Bharati Sakshi Adhiniyam. We will talk about it at the later stage. I will talk about one important thing. Then we'll, hearsay evidence. Okay, this is another concept. Then we'll talk all those things, BSA, all those things, we'll do that. Okay, what is hearsay evidence? It is second-hand evidence. Okay, a statement not made by person. It is, he heard from somebody. Okay, you say that I heard that neighbor is saying that somebody killed somebody. So you didn't see that. And you are not witness also for that incident. You heard from a neighbor. Okay, that is hearsay evidence. It is second-hand evidence, not direct evidence. Okay, so hearsay evidence is not acceptable in the court. Hearsay evidence, second-hand evidence is not acceptable in the court. Okay, then exceptions for hearsay rule. Res geste is the exception. Section 6, res geste says that statements forming part of the same transaction is exception. Res geste is statements forming part of the same transaction. So that particular evidence is connected to the fact in issue. I'll see it is this is exception. So if there is a okay, so this is very important. Otherwise, you will get confused. Res geste is I'll explain with an example. So the facts must be connected to the main fact in the issue. Okay, and it should be part of the same transaction, and it should be relevant. And essential conditions are given. The statement must be spontaneous, okay, and not afterthought. It must be contemporaneous with the instant or immediately after. There must be direct connection between statement and occurrence. Okay. So why this is important? Because it is natural, unmanipulated truth. So they accept res geste as a exception for what is this? For hearsay rule. Okay, res geste they accept as a exception. So what is this hearsay rule? So there is say somebody stabbed somebody. Okay, let us say A stabbed B. Okay, so you were in that particular place, some place. You didn't see A stabbing B. But when A was stabbing B, somebody in the crowd shouted, "Arey, A is stabbing B." When the stabbing was happening, you were not seeing that. But at the same moment, somebody in the crowd shouted that "Arey, A is stabbing B." Or a person in red shirt is stabbing another person. Something like that. Okay. So that evidence immediately given. When the instant is happening, it is connected to the fact. At the same time, it is spontaneous. It is contemporary with the instant and immediate effect. It is not an afterthought that after 2 days somebody told you, you heard. No. You were there at the time of accident, but you didn't see. But somebody in the crowd shouted, "I saw A killing B." Okay. Then you can say, "I heard at the same time, within 1 minute, I saw there. I don't know who killed it, but I immediately, A is stabbing B. I heard that statement." That is res geste. So that is exception for hearsay because you are not witness for that thing, but you are a secondary witness. Okay. You are a hearsay witness because you didn't see that one. You heard somebody saying that, but it is an exception. Res geste is exception because it is forming part of the same transaction and it is spontaneous. If there is a gap after half an hour, 1 hour, if somebody says no, it is not accepted. You were there at the time. Within moments you saw, but you didn't see A stabbing B or A killing B. But somebody saw that and they shouted and you heard that at the time. So that is accepted as evidence. So you got the clarity about res geste, right? Because somebody was asking question about res geste, I thought I'll give that because I cannot type and explain all these things in WhatsApp. So that is the reason I told on the day. I will explain it in the class. You got the
repeat cheyra, sir?
Is res geste na?
Yes, sir.
See, hearsay evidence ante ఎవరైనా వేరే వాళ్ళ దగ్గర నుంచి విన్నది మీరు చూసింది దాన్ని hearsay evidence అంటాం. అది ఎవిడెన్స్ పనిచేయదు కోర్టులో. సో సార్ ఏ బిని చంపాడంటే నాకు మీకు ఎలా తెలుసు అంటే నేను విన్నాను సార్ అంటావు.
ఓకే.
అది యాక్సెప్టబుల్ కాదు. అది హియర్సే ఎవిడెన్స్ అంటాం దాన్ని. సో హియర్సేని యాక్సెప్ట్ చేయదు కోర్టు. కానీ దానికి ఎక్సెప్షన్ ఏంటంటే రెస్ జస్టే ఎక్సెప్షన్. అంటే హియర్సే ఎవిడెన్స్ ఎప్పుడు యాక్సెప్ట్ చేస్తుందంటే సార్ నేను విన్నాను సార్, నేను నాకు చూడలేదు, నేను ఆ టైంలో అక్కడే ఉన్నాను చంపేటప్పుడు, కానీ నేను చూడలేదు, కానీ చంపేటప్పుడు వేరే వాళ్ళు అరిశారు ఏ బిని చంపుతున్నాడు అని. అప్పుడే చంపుతున్నప్పుడు అరుస్తున్నాడు, అరే చంపేస్తున్నాడు, ఏ బి చంపుతున్నాడని అరుస్తున్నాడు. నేను విన్నాను, చూసేసరికి ఏ పారిపోయాడు. నేను అతన్ని చూడలేదు కానీ తను చచ్చిన వాడిని చూశాను. అది అప్పుడే జస్ట్ హాఫ్ మినిట్ లో నేను చూసాను, అక్కడికి వెళ్ళి చూశాను అని చెప్పొచ్చు. సో
ఓకే
దాన్ని రెస్ట్ జస్టిస్ అంటారు. అది అనమాట, అంటే దాన్ని యాక్సెప్ట్ చేస్తారు.
ఓకే సార్.
ఓకేనా? అది రెస్ట్ జస్టిస్. ఎందుకు
ఇమీడియట్ గా చూసాను.
అంత ప్లాన్ గా అప్పటికప్పుడు ఎవరు అరవరు, ఏని బీని అలా చెప్పలేరు కదా.
ఓకే
సో దాన్ని యాక్సెప్ట్ చేస్తారు. హియర్ సే రూల్ కి ఎక్సెప్షన్ అన్నమాట. ఇది నువ్వు వినలేదు, నువ్వు చూడలేదు, కానీ నీవు విన్నావు అయినా నిన్ను యాక్సెప్ట్ చేస్తున్నారు ఎవిడెన్స్ కింద.
ఓకే
ఎప్పుడు ఇమ్మీడియట్ గా స్పాంటేనియస్ గా విన్నావు, ఇట్ ఈస్ కనెక్టెడ్ టు ద మెయిన్ ఇష్యూ. ఓకేనా? సో అది రెస్ట్ జస్టిస్. సో ఇది చాలా ఇంపార్టెంట్. సెక్షన్ 6 లో ఉంటుంది ఇది. ఓకే, దెన్ ఇప్పుడు మనం సివిల్ లో యూస్ చేస్తాము, క్రిమినల్ కోర్ట్స్ లో యూస్ చేస్తాము మనం చెప్పాం కదా. వి టోల్డ్ దట్ ఇట్ విల్ బి యూజ్డ్ ఇన్ క్రిమినల్ కోర్ట్స్ అండ్ సివిల్ కోర్ట్స్. బట్ సేమ్ టైమ్ ఇట్ విల్ నాట్ బి స్ట్రిక్ట్లీ ఫాలోడ్ ఇన్ ట్రిబ్యునల్స్, కన్స్యూమర్ కమిషన్స్ I told right when I was there. So but it is there in the complaint. See, don't scribble on the screen. It is there in the what we say complaint itself. So I argued that. So tribunals will not accept. Lot of tribunals, so they will have lot of other ways to prove things. Consumer courts will not go through strictly through Evidence Act. Labor courts and even some other forums also, even many other tribunals and commissions, they will go based on natural justice. Okay, based on natural justice, not based on Evidence Act. So this is very important thing. In tribunals, photocopies are allowed. Okay, but in courts it may not be acceptable. So affidavits are acceptable in tribunals, they carry weight. Affidavits, almost all evidences are through affidavits only in consumer forums. Okay, lot of such things are acceptable as evidences in tribunals and forums, but not in courts. So where it is taken there? Okay, then we'll go back to. So now the thing is, they have come out with a BSA, right? New act. So BSA is replaced in 2023. The Evidence Act is 1872. So main is to bring in the changing modern delivery system. So digital systems have come. Now you can see a lot of courts are also having filing, e-filing, everything they are doing on digital format itself. So earlier emails were not accepted, photos were not accepted. I mean from web, WhatsApp things are not accepted. Now courts are accepting WhatsApp chats with certificate. Okay, so all those things, to accommodate those things, IT Act has come. So to accommodate IT Act related provisions, they have changed some sections. But now in Bharatiya Sakshi Adhinayam, they have made it more near to the modern digital era. Okay, so main key changes are digital evidences recognized broadly. So section 61 to 63 of BSA, electronic digital records given equal footing with paper documents. Okay, even digital signatures are accepted, metadata is accepted, blockchain is also accepted. Electronic communication expanded. So I told WhatsApp, SMS, email, CCTV footage, GPS locations, cloud data, all those things are accepted. The document definition, earlier, see, all those definition you find it in the textbook itself. In the section 3 you find the definitions. Document is also defined. So you can say where it is defined. Document, you can see the document means matter expressed or described upon. See, there was a question about the same thing. Document, they gave this exact thing. Okay, this particular item is not there in the definition. As per document definition, they gave that entire definition, which is the wrong word used in this definition. I mean, they have used one or more maybe sentence. So you can just go through that definitions part where exactly you can check it and you can answer that question. Okay, so document definition is now broadened. Now it includes, earlier it was not there, so they may ask any recorded, stored or transmitted digital form. So they may use one thing. So digital form is used in when it is amended, whatever it is. So they may give certain question, such question. So you should know where document definitions lies. Document definition lies in section 3. Okay. Interpretation clause. All the definitions are there. Code, fact, document, evidence, proved, disproved. Okay, not proved. So okay, I told I will talk about proved, disproved, not proved. Right? Proved. A fact is said to be proved when, after considering the matters before it, the court either believes it to exist or consider its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. Proved means proving, simple. Okay. Opposite of proving is not proved. Okay, now disproved. So opposite of proving is disproved. Be careful. Okay. Proving is one thing. Disproved is opposite to proving. So after giving all those things, court believes that it is not there, not existing. That is disproved. Proving is court believes that it is existing. That is proved. Not proved. Be careful. Disproved and not proved, there is change. Not proved is whether it is not proved or disproved. Not proved means it is not proved and disproved. Not, just take it differently. It is not proved or disproved. First two things what I told. Proved, disproved, it doesn't belong these two things. It is in dilemma, then it is called not proved. Okay. So document definition is broadened there. They removed some old illustrations and colonial references when they were referring to the king, kingdom, queen, all those things. Those things are removed from evidence and they have brought in new evidences. Streamlined presumptions. Okay. Then uniform application for civil and criminal matters. They have made some uniform. Okay. So these are the major changes. I'll see if I have missed anything. So basically, as I told, most of the questions, we will do some practice sessions. You will understand that the questions are from BEAR Act only. It will be through index, through sections, or through illustration. There are three types of questions: sections, illustrations, and index also. You can answer it that way. Okay. So there are three parts, as I told. Part 1, section 5 to section 55. It is about relevancy of facts. Facts which may be provided before the court. Okay. Section 56 to 100 deals with the proof. Rules as to what type of evidence may be given, oral or documents required to prove that things. 56 to 100 talks about these things. How you prove those things. Okay. Then section 101 to 167, it is the burden of rules regarding witnesses and their examination. How witnesses are examined, cross-examination, chief examination, and hostile examination. All those things are between 101 to 167. It is very small act. It is only 167 in old one. I think in the new, I'll just check and tell how many sections are there. New BEAR Act I had to open. I don't remember exactly. It is 170. Just another 3 or 4 extra sections are there. Okay, 3 sections extra are there. Okay, 170. So you try to read the entire BEAR Act index. I have shared it with you, 3 parts. You should know where exactly it lies. That is the reason I gave you 3 parts. I explained about 3 parts, how it appear in this thing. Okay. part 1 deals with some things, part 2, part 3, whatever it is. So you will understand which part that particular section or anything lies. So part 3 deals with evidences, how you go, how you bring, how they cross-examination. If anything related to cross-examination or anything, it will in part 3. If it is related to documents, how you to prove, how not to prove, it is in part 2. And what are the accepted things in the court, it is in part 1. Okay. So these 3 things you have to remember, basic things. I told about primary, secondary, hearsay evidence. Then there are definitions are there. So I am not speaking about definitions. Section 3, all definitions are there. Okay, really, fact, code, all those things are defined, proved, not proved, evidence. All those things are part of definition only. Presume, may presume. I spoke about presume, all those things. Okay. So doctrine of res geste I spoke. So dying declaration is another important thing. You may get question. A dying declaration is given by the person who is about to die. Okay, they take it as a truth until there are certain exceptions are there for dying declaration. Okay, so they presume that he speaks truth in that last stage. Okay, a dying declaration is a declaration written or a verbal made by a person as to the cause of his death or to any circumstances of the transaction which resulted to his death. That is his dying declaration. Okay, when it relates to death, when it is made in the course of business against the interest of the maker. Okay, so that is basic things you have to remember. So dying declaration is one thing you may get some questions. Okay, dying declaration is statement made by the person who cannot be called as witness. He cannot be called for witness. He already died and he is giving his thing in verbal or in written statement, the reasons for his death. So facts which not be proved, I told, when it is accepted or when it is not denied, it is need not be proved, and it is visible clearly, need not be proved. Okay, so these are the things we have. So we will take questions.